afternoon and welcome to today's webinar, Trust Systems and Trusting the System, Estate Planning and Brain Injury. Thank you for joining us today. My name is Barbara Chabner. I'm the Director of Education and Outreach here at the Brain Injury Alliance of New Jersey. And for those of you that don't know and are not familiar with us, the Alliance is a nonprofit organization with a mission to provide education, awareness, prevention strategies, advocacy, and support for those who have been affected by brain injury. I just want to let people know that on our website, there is a tab where you can view and register for all of our upcoming webinars for the next few months. Our next webinar, as you can see on the screen, will be held on October 24th on the use of virtual reality in brain injury population. And we have some other webinars coming up as well. And you can register for all of them when you go to our Brain Injury Alliance website under the resources section. I also want to mention that we have our walk, run, roll for brain injury awareness this Saturday at Bradley Beach. If you haven't signed up yet, there's still plenty of time to do so. We'd love to have you form a team, come by yourself, make a donation, however you want to participate, but we would love to have your participation. So now just for a few housekeeping notes before we begin the webinar. Attendees' microphones have been muted. If you have questions during today's webinar, please type them in the Q&A box. We will get to as many questions as possible at the end of the presentation. Although our presenter has indicated that he's happy to answer questions throughout the webinar rather than waiting all till the end. So if you do have questions, pop them in the chat. We'll try to get to them as we can. The webinar is being recorded and will be available for viewing on the BIANJ website. And I do want to add also that you will receive an email the next day or two, a follow-up email that will have the slides and a link to the recording. So, I know we often get questions whether the recording will be available or slides available. So you will receive that. At the end of the webinar, the link for a post-webinar survey will be placed in the chat. We value your feedback, so you're encouraged to complete the survey. You must complete the survey in order to receive a certificate of attendance. Once you complete the survey, you will automatically receive your certificate of attendance via email. Our presenter for today is Ryan Crocker. Ryan Crocker received his bachelor's degree in psychology from the University of Chicago with a minor in Spanish, and he received his Juris Doctor from William and Mary Law School. He is licensed to practice law in Pennsylvania and New Jersey. Ryan is fluent in Spanish. He began his career as a litigator, working on matters in federal and state courts, as well as proceedings before the Department of Labor. Ryan gained several years of experience in estate planning, estate administration, and Medicaid planning, working for an estate planning and elder law firm in central New Jersey before joining Rothkopf Law Group. Ryan is a member of the Pennsylvania and New Jersey State Bar Associations and the Bucks County Bar Association. When he's not working, Ryan enjoys reading of all genres and kinds, learning trivia via Wikipedia, and spending time with his wife, young son, and middle-aged cat. I'd like to welcome Ryan, and you can pop your slides up, Ryan, and we can begin.
Good afternoon, everybody. Thank you for having me. Thank you for the kind introduction to Barbara, and thank you, Brain Injury Alliance New Jersey, for having me. I'm going to get my slides started. This could be interesting. So let's see. Visible, yes? All good.
Yes.
See Barbara nodding. Okay. So, as you can see, we have the title of the program here. We have my name, we have my information, including my email. If you have questions afterwards and I'm not able to get to them, you can always send me an email or give us a call and we can see what we can do. If it gets into the point where it's representation, I'm going to let you know. If it's before that, I'll happily answer. So in terms of what we're going to be talking about today, I'm going to start by setting out the framework. There's basic documents that everybody should have, which would be a will, a financial power of attorney, a healthcare power of attorney. And there's some more complicated stuff, which some people need, some people don't. I'm going to talk about when that applies, special needs trusts, what they are, what they can do, why they exist, why this should all matter to you. Uh, as a planning attorney and as someone dealing with this, a lot of the time I will help someone put a plan together. I'll give them a huge stack of documents. They'll take them and put them in a filing cabinet, and I try to put in my file where they keep them because I get those calls. And I want to make sure with clients and with people thinking about this that they understand why this matters, and what can happen if you do nothing for yourself, for your family members, for those with a brain injury, all that kind of thing. There'll be a set Q&A session at the end, but as Barbara said, if you have questions in between, you can put them in the chat. I'm going to try and rely on Barbara to kind of MC there and pick ones out as we go. And yeah, looking forward to spending this time with you. So, basic documents, financial power of attorney. Well, first thing about the basic documents and the first thing about legal work in this kind of area is that every estate planner, every state, every attorney, person doing presentations on webinars at noon thinks that they have a clearer and more direct name for each document. So the unfortunate truth is that other than the will, these documents can have very different names at the top of the actual paper itself and do the exact same thing. So these are the documents and their AKAs, and I'm going to go through one by one, talk about what they actually do. So there's a financial power of attorney. You can see the other names there. It can be general, it can be durable, it can be occasionally you have ones that are limited. You have a healthcare power of attorney, which is a person making healthcare decisions for someone else. There's a whole slew of names there. I think New Jersey in their statutes, they call it an advanced medical directive, but there's a proxy directive, there's a instruction directive, and the key difference there is that the proxy is the person, and obviously the instructions are the instructions. I want this treatment, I don't want that treatment, all that good stuff. Last will and testament is what you would think. It's the document that in movies everybody gathers around. The attorney who often has a bow tie. I do not have one. I don't have any actually, just for the record. The attorney who's often in a bow tie and a sweater like this one will read out the will. Parenthetically, I'll say that nobody does that in real life, at least in Pennsylvania or New Jersey. If someone does have a reading of a will, it's going to be really boring. They're very long, very detailed. People just get noticed in other ways. But so those are your three foundational documents. Pushing forward, if I'm able. So financial power of attorney, sometimes called general durable power of attorney, because it is a little more than finances most of the time. But the bulk of it is the person who can handle your money for you, who can file your taxes for you, who can, well, negotiate with the IRS in a bad situation, who can do all sorts of things. Any kind of financial official life of yours, depending on how detailed the power of attorney document is, it's going to delegate all or many, 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 or just a couple of those powers. Occasionally, you'll see a power of attorney used for things like a real estate closing, and somebody doesn't want to show up, getting bonds and insurance and that kind of thing. But what I'm thinking about here, and what I would suggest that you all think about, is a power of attorney so that when someone cannot handle their financial affairs, or it's extremely inconvenient for them to handle their financial affairs, there's someone else who can go to the bank, just by way of example, and they can hand over this packet, this document, this general durable financial power of attorney at the top, and say, I can sign for my son, for my brother, for my spouse. And that's a key thing as well, which is if someone's married, that doesn't mean that their spouse gets power over all their accounts. You have to have a financial power of attorney in place if someone is going to go in and handle an account or an asset that is in your sole name. People think that when they get married that their spouse is going to start digging into their bank accounts, and maybe they are, but from a legal perspective, you can get turned away at the bank if you're trying to go into an account that is in your spouse's sole name and you don't have power of attorney. In fact, you probably should be turned away at that point. And one of the key things with this document that I think about all the time when I'm drafting and I'm explaining to people and I'm thinking about its use is what it looks like pragmatically. And I'm going to give an example situation, hypothetical, going to increase my kind of professorial factor here as much as possible without growing a goatee. And we're going to talk about what this looks like when you actually use it. Because it's all well and good to have it written, but if a bank won't take it, it doesn't do anything. Looking at my bullets here, it should be durable. And when I say durable, I don't mean that it should be laminated. I mean that it should endure, even if the person who has created the document, who is delegating their power to another person, becomes incapacitated, becomes either completely unable to communicate or unable to understand what they need to do. And that's why I've got those two block quotes there for Jersey and PA, straight from the statutes, talking about what disability looks like and what it means for it to be durable. In Jersey, we've got the magic words on the left. I've bolded and underlined them because I guess I have a flair for the dramatic here, but words that are similar enough, or in my case, just those exact words, will make it so that a power of attorney will continue to be in effect, even if the principal is incapacitated. This might be a kind of facepalm moment for someone here where they're saying, yes, Ryan, I understand financial power of attorney, the person's incapacitated. But the thing is that a lot of these documents are very traditional. They have a long history, a lot of them. We're talking hundreds, if not thousands of years. And well, maybe not thousands for power of attorney, but anyway, it'll shake out in the recording. But in terms of how powers of attorney traditionally work, it's a delegation of powers that you have now, you being the principal, right? So I write a power of attorney and I say that my wife can handle all my finances and write checks for me and deal with the IRS and pay my medical bills and all this good stuff. And it has to say that it's durable in New Jersey. In PA, if you're a PA resident, it's presumed to be durable unless it says otherwise. Okay. Which makes a lot more sense, but I'm not a state senator anywhere, so you can take that up with your local representative in New Jersey. But traditionally, the rule is you can't delegate something you can't exercise yourself. So how could you delegate the power to go to the bank, negotiate, sign, if you yourself can't sign? But everybody's realized, not everybody, but the legal community and people as we are, have realized that that doesn't make a lot of sense when the principal being incapacitated is the time when the power of attorney is needed most. It's when it's needed most and someone is going to be handling those things. So durability exists. It's a wonderful thing. If you have a power of attorney that isn't durable, I sincerely hope that it's just for a quick transaction or something like that, and not the one that you expect your family members to rely on in the long term. In my strong opinion, a financial power of attorney should be effective as soon as you sign it. This makes people nervous. This makes people think about who they're naming as their agent, and it should. The long laundry list of powers you see in this kind of document, you should trust the person that you name, or they should trust the person that they're naming as their agent implicitly and completely. If you don't have an agent that you'd be willing to have all the logins to your online banking and be able to handle your checkbook and sell all your stuff and hire an accountant for you to do your taxes, hopefully, they shouldn't be your agent. It should be effective now, and it should be someone that you trust immediately, because if it only comes into being when you are incapacitated, which is another option, it's called a springing power of attorney. I do not favor it, but if you have a springing power of attorney, you're conferring that trust on somebody when you're not able to check on it. You should trust them now when you do it. It also means that if it's effective immediately, rather than someone having to get a doctor's note saying that it has sprung, shall we say, it's just in effect already. And again, thinking pragmatically to the person standing at the counter in the bank, being able to point to the first page and say, it's effective now, rather than someone having to call the principal, call the doctor, just makes everything easier and it makes it effective. So here is my hypothetical. So this is it in practice. So we've got dad. Uh, Dad has a son named Greg. He's got 5 other kids. They may or may not have a surname. Sounds like Brady. We'll presume here that dad is widowed or for whatever reason. He has a accident at a building site for his job. Breaks this bone and that bone, and he's just laid up. He can't go to the bank. He wants to get cash out so he can, make some gifts or whatever it is. Um, and he just can't. So he sends his son to the first bank of small town with the power of attorney document in hand, and he says, "Get me a cash withdrawal of, $2,000." He's the best granddad anybody could think of. And the question is, what happens? I've given you a little multiple choice here. I'm going to give you a hint and tell you that the teller does not actually unmask Greg as an imposter and get several awards for their civic responsibility. That is not usually what happens. Actually, I haven't heard of it happening, but if you do here, I would love to know. Um, and the question is, does the teller accept the POA? Do they reject it? Do they get very nervous, call the manager, and put Greg through a kind of Rube Goldberg machine of various processes? And the answer is that it's usually, well, the answer is it depends, which is very lawyerly. I'm very sorry about that, but I can't escape my profession entirely, especially when I'm working. So instead, what happens is if the POA is recognized fully and the teller accepts it, great. They'll usually put it on record. They'll usually either take a photocopy or they'll take the original and they'll actually send it off to some back office, and they're always in Nebraska, South Dakota, wherever. They'll mail it off. Someone looks it over, says, yes, this is fine, and sends it back. They could take it right then. They could make you wait 6 weeks. Uh, it really depends on the situation. But the most common outcome is C, is that the teller gets really nervous because when you're using a power of attorney like this, you're walking into a bank and you're saying, I am not dad. I'm Greg. And I need dad's money right now. And I need you to give it to me. I need to let me cut a check, or you need to tell me all the balances or whatever it is. I need access. And tellers and people who are just average folks working at banks don't know what's going on. And they're worried about abuse of someone else's money, all these kinds of things that are actually completely and utterly, not completely, but they are mostly outside of their wheelhouse. Um, they are mostly something that they're not supposed to check into. They are not supposed to call dad necessarily. They're supposed to just accept it. And if dad was in a coma instead of home with 2 broken legs, or dad was in a motorcycle accident, had a traumatic brain injury, he's not able to handle this kind of thing, just thinking about folks that we're talking about here, the bank isn't really supposed to or require any input from dad here. The document is supposed to be sufficient. The notarization that's on it is supposed to say that dad is dad, that he's the one who signed it. The formalities and all that kind of thing that are required, witnesses, notary, it's all supposed to ensure that it's a valid and good document that they can accept. But in real life, people get really nervous about this kind of thing. They might ask for a doctor's note when there's no one to give. And if you have one, you can give it and you're great. But you can also get stuck. So with a power of attorney, if you, any of you folks here are ever using one, and I hope you're not, or if you are, it's a pretty low key type of thing, like dad having his building site thing. Well, it's a serious injury. If you are using it, it's key that you stick to your guns, essentially, and that you say, this is a valid power of attorney and I can use it. I mean, presuming that it is a valid power of attorney. Um, if you have a power of attorney that you printed off of, eforms.com or LegalZoom or something like that, there's a chance that it's perfectly fine. And that's great. And hopefully you got it witnessed and notarized and all that good stuff. And of course, the principal has signed it. In PA, it has some additional formalities and that kind of thing. But even if you have an attorney prepare it who knows what they're doing and it's all well and good, you still might have to stick to your guns and push back and say, this is fine and I have this authority. And the person you're asking about can't answer your questions. They're incapacitated or they've already signed it years ago or whatever it is. But you have to be strong with it. I mean, don't whack the teller over the head with the document, but maybe metaphorically. So, or figuratively, I guess. All right, so that's it in practice. A key thing about this document, about all of them really, which I should have given another slide, but you think about these things on the fly, is about capacity. Someone can't sign a power of attorney or a healthcare power of attorney or a will unless they have the capacity to understand it. And the threshold for that is a legal question. It's also kind of a medical question too. There's a significant overlap. But when the document is being actually executed, it's a legal question because these are legal documents. And one of the things that I do as an attorney when I work with elders or people with traumatic brain injury or cognitive decline or whatever it is I evaluate their capacity to understand. For a financial power of attorney or healthcare power of attorney, it's a contract level of capacity. And I'll be careful before I go too deep into the weeds here, but they need to understand what they're signing. They need to understand what powers they're delegating. They need to understand the situation they're in. They need to be oriented, all that usual kind of capacity testing stuff. And they need to know that they're, in this case, delegating power over essentially all their money to another person, effective immediately in most cases. They need to get that. Someone who has a traumatic brain injury, someone who has cognitive decline from other causes, uh, their capacity is not a one and done thing. I mean, I'm sure there's folks attending here who have family members who've had TBI or cognitive decline or dementia or whatever it is, and it can ebb and flow. Someone can have a lucid interval, I would say. They're good in the morning, they're bad in the afternoon. Today is not a great day, but tomorrow is totally fine. That can matter. What matters is the capacity when the person signs. Just like if I signed a power of attorney today, and then I had some sort of accident, a TBI, I'm not able to understand what's happening at all. I had capacity when I signed, so when my wife uses it in future, it's valid. That's the key. So something to think about there. All right, I'm going to move forward. Healthcare power of attorney. This one is
I'm sorry, Ryan,
oh,
I'm
yes.
going to intervene here for 1 second.
Mhm.
We do have a question
Great,
on that example. So
of course.
we'll go with that. So once you use the POA at the bank in this example, would dad
Mhm.
be able to still go to the bank when he can walk again? Or would it be
Absolutely.
Greg who has to take care of things from now on?
Yeah, dad can go to the bank, everyone. You delegate the power, but you don't take it away from yourself. For example, I continue to handle all my bank stuff and paying certain bills and all that good stuff with my wife, even though she has valid power of attorney. And you can revoke a power of attorney at any time that you still have capacity as well. You can amend a power of attorney at any time. None of these documents you make during your life, um, I'm using the you here, but that one makes during their life are set in stone. They can be changed, revoked, and to return to your question, you don't take power away from yourself signing a power of attorney. You let someone else exercise it on your behalf. Good question. Thank you.
Well, I got one more here before
Mhm.
we go on. Do these documents hold across states, or do these documents need to be completed wherever the principal resides?
Yeah. Oof. Yeah. That's my answer. Um, so there's a little thing called the full faith and credit clause in the Constitution that says that the states are supposed to respect each other's laws. So if you have a power of attorney validly executed in the state that the person was living in at the time, then you should be able to use it in another state. However, again, in practice, if I go to the bank I'm sitting in Pennsylvania today, so I'll think about it that way. If I took a New Jersey power of attorney to a Pennsylvania bank and I said, here's my power of attorney, or here's my mom's power of attorney, I need you to let me access her bank account, the person there has probably seen a Pennsylvania power of attorney before, and they know in this example that a Pennsylvania power of attorney has a cover sheet on it that's set by statute that must be signed by the principal, and it must be in all caps. It like screams at you. And if I hand them a Jersey power of attorney that doesn't have that perfectly validly executed in New Jersey, uh, they might push back on me and say, I need that cover sheet to know that this is a valid power of attorney. They could be completely wrong, and they are in that case, but it's going to make things harder for you. So if you have someone who has moved, I think they should update their documents. I mean, I would say that I'm a estate planner and attorney, and I think everybody should have the most up-to-date documents they can think of. But if you move state to state, I think you should update things to what's local just to make things smoother, even if the law and everything would be on your side to try and use it from another state. Another good question. Thank you. Are we good, Barb? Oh, I don't know if you're a Barb.
Yep, that's fine. We'll go. Yep, go ahead. Thanks.
Alrighty. So, healthcare power of attorney. This is a document that says who can make healthcare decisions for you when you cannot speak for yourself. I try not to read off my slides here, but that is truly the crux of it. This document, it can say that it's in effect immediately in PA. In New Jersey, it only comes into effect when you are unable to speak for yourself. That could mean that you're incapacitated. It could mean in the sense that someone is in a coma or lacks the cognitive ability to recognize what is being asked of them or that kind of thing. But it could also mean just that you cannot communicate. Yesterday, actually, I had a meeting with a man who had a traumatic brain injury, brain bleeding, really tough situation in his 50s. He can't speak. He can't really move much. Um, he can squeeze a hand, and as I'm sure many of you know, he's in a situation where his eyes can move freely. Um, but controlling his blinking is a little difficult. Uh, his mom was there with him, and I was able to communicate with him through squeezes of the hand. Um, he would squeeze his mother's hand or my hand, once for yes, twice for no. I could ask him questions. I was able, through yes or no questions, to uh, ascertain that he understood what we were doing and why we were doing it, what his family setup was, who was there with him. Uh, you can guess that that gets a little persnickety. It can be a difficult process, but if you can still communicate even to that degree, you can make healthcare decisions for yourself if it's clear that you can understand what's being asked of you. Uh, that's the degree to which a healthcare power of attorney will hold back until it's necessary. In New Jersey, that is by default. In PA, technically it can be in effect immediately, but again, in practice, if a doctor or a nurse or a healthcare professional is able to communicate with you, they are going to ask you and want your opinion. This document should be durable. Again, in PA, it's presumed durable. In New Jersey, it needs the kind of magic words there. If it's not durable, it doesn't do much. It really doesn't. Because when someone's incapacitated is when it is needed, and really the only time. For formalities, again, for this one, I would recommend that it have two witnesses. They cannot, generally speaking, they cannot be someone who is working for a place where someone is receiving healthcare. The doctor, the attending, the nurse, the aide. They're not supposed to be witnesses to these documents, and they are certainly not supposed to be the agent unless they are a family member. And even then, probably the person would excuse themselves from it. So they should be independent witnesses, ideally, and it should be notarized. In PA, you can get away with just having two witnesses and then no notary, but I don't really recommend it. Um, you can usually get a traveling notary, or if you're working with a law firm, they're going to have notaries coming out their ears probably. Um, and in New Jersey, attorneys, just by dint of being an attorney and admitted to the bar to practice law, can notarize documents with their signature. They don't usually have a stamp and seal, but if you or your attorney is notarizing something for you, I recommend that they write in the statutory site that says that attorneys can notarize. But anyway, so healthcare power of attorney in practice. This is a true story, and the names have been changed to protect the innocent. But I'll summarize here. But Matthew and Janine are a couple. They're not married. They've been living together for a decade. They've been together longer than that, but they are not married. And neither of them has any documents. In this case, no healthcare power of attorney. Matthew thinks he is a real tough cookie. So he has some pains in his abdomen on one side, and he does nothing. He does not go to a doctor. He complains a little bit to Janine, who tells him immediately to go to a doctor, and he does not. Um, this goes on for about a month. The pains go away. If there's a medical professional in the audience, they're cringing right now. The pains go away and then they come back and he has a little swelling in his abdomen. He says, you know what, I'll go to the doctor. They say, get thee to the ER right now. You need your appendix out right now. The doctor there says, sounds like an appendectomy, my fifth one today. You can expect Matthew out in 2 hours. In real life, this was about 6 p.m. They said you can expect him out at 8 p.m. Uh, at 9 p.m., Janine goes to the nurse and she says, what's the status? It's been 3 hours. I was told it'd be 2 hours. Is he in a recovery room? What's up? And the question is, what was the response? Did the nurse say, here's his chart, here's the update, here's what's going on? Did the nurse say nothing and refuse to give anything else? Did the nurse call the doctor and say, she will let you know what's going on? Did the nurse say to Janine, you are not Janine, you're not the person that you're supposed to be, tackle her over the top of the desk and hold her until the appropriate authorities can arrive? The answer is not D, again, as expected. My feeble attempts at humor continue. The actual answer as to what happened in real life in a Baltimore hospital is B, nothing. She gave no information whatsoever. She would admit to Janine that Matthew was there, considering she walked in with him, but she wouldn't give her any further information. She wouldn't say how anything was going. She said, you don't have a HIPAA release, HIPAA. Again, healthcare professionals in the audience might be cringing a little bit. It's an infamous federal statute about protecting healthcare information, which is more of a hammer than a scalpel, if you're asking me. And she said, you're not his healthcare proxy. I can't talk to you about it. And you're not married, which sometimes medical professionals will talk to a spouse. And under HIPAA, they'll allow that. But they're not married. And Janine made the mistake of saying, I'm his girlfriend. And the nurse said, well, then I'm very sorry. Actually, she didn't say that. She's a Baltimore City nurse. She said, no dice. I won't tell you anything. Ultimate result was that Janine had to call Matthew's mom. Matthew is an adult man. The mom called the hospital. The hospital was willing to talk to the mom. And then it was a literal telephone game to figure out what had happened, which I don't think my friend would mind me saying, was that his appendix had turned into cement and attached itself to his large intestine because he didn't do anything about it for over a month. He ultimately got out of surgery at, I think it was like 1 o'clock in the morning, and they still wouldn't tell Janine anything directly. And by that point, his mom had gone to bed, so she slept in a waiting room. 6 o'clock in the morning, she managed to get in and talk to him. She had gotten the the information that he was okay and out of surgery, but they wouldn't let her go back. So yeah, that's my horror story there. You should avoid that. If you're married, you can probably skip around it a little bit for a spouse. But when you've got kids who are over the age of 18, it's not necessarily the case that they're going to talk to you. If you have a relative, a brother, a cousin, a nephew, an uncle, I don't know why I'm picking on all the male relatives here, but that has a TBI, something like that, folks aren't necessarily going to talk to you just because you have good intentions and a nice smile and a golden handshake. They're going to want to see documentation, a HIPAA release, or a healthcare power of attorney to help uh, them know that you can make the decision. This is another kind of natural stopping point for questions folks are ready for them.
There are a few,
Okay,
not
I'm going to
necessarily
rely on you to
related.
pick and choose.
Okay, yeah, not necessarily related to this example, but we'll go with it.
Mm,
So, so someone's asking about revoking the POA and like making changes.
mhm.
Is it hard to do that? And how do you do that? How does that work?
You do it in writing, and it can be as simple as a letter that you write and you sign and date. But again, in practice, the problem is that if you have six different bank accounts, because Bank of Princeton had the best CD rates this year, which, fair enough. And you've got this account and that account and that account, and your POA, the old one, is on file with them. You need to send that letter to all your financial institutions and say, I have revoked my prior POA, and my nephew, who's, fallen into a gambling addiction or whatever, is no longer able to do this for me. If you just write the letter and you leave it in your desk, it's not going to help you. You have to make sure it gets to the right folks, but you should do so in writing so
Okay.
people have something to point to.
Okay, great. And then another question is, I guess, relating to the healthcare proxy. Is this different from a DNR? The should
Yes.
person. So yes. What time after place? Yes. So it's. Can you just briefly explain the difference
Yes.
and whether it's
Yes,
the
absolutely.
question also has to do with how long something stays in place.
Yeah. So these documents will stay in place until you die. The power of attorney, financial, and the healthcare power of attorney, they're your delegation of your power as a living human being. And we can stretch the traditional rule as far as durability, but we cannot stretch the traditional rule as far as your life. If you are deceased, these will not function anymore. Pragmatically, again, sometimes the bank doesn't know that you're deceased. That is not correct, is not the way to go about doing things. But I have known people to come into my office and say their family member's deceased, a week ago, and 2 days ago they made a transfer out of their bank account, and I say, oops, and they say, oops, and then we figure it out. But as far as the difference from a DNR, a do not resuscitate order, um, I do not have the right letters after my name. Specifically, I do not have MD after my name or DO or NP or any of those in order to execute a DNR. A DNR is a medical order. What I, as an attorney, can do is execute a living will, which is yet a separate document. Sometimes it's folded into the healthcare power of attorney. Sometimes it's not. Sometimes it stands alone. And it is also called, that's the instruction directive that I referred to a little bit earlier in my long rambles here. It's a document that says what types of treatment the principal would want or not want, written by the principal as a direction to their healthcare proxy, to their agent under the healthcare power of attorney, which is the same thing. It can be highly specific. It can be highly general. The living will often runs in parallel to a DNR, saying things like, if I'm in a consistent vegetative state, I'm not going to come out of it. My doctor says that I'm not going to come out of it. Then I instruct you, my healthcare agent, not to continue life-sustaining treatment. Kind of a Terry Schiavo type situation for those who recall that. That is what a living will does. It's what an instruction directive does. And when I draft, I usually leave it to the client to fill those out because they are deeply personal. They can be highly specific, and they are often not binding. An instruction directive can be binding, but the situations medically are just so hard to predict, even if you are a medical professional. And I have to say, the folks I've seen who gave the least, cared the least about the instruction directive were almost all doctors, nurses, folks who worked in long-term care medically, because they know that sometimes if you're too specific, it can be a millstone around your agent's neck because they're trying to work within the boundaries of what you put down when you said, for example, I don't want opiates ever. That's what you said when you were thinking about your, brother-in-law who has an opiate addiction, and you thought that can never happen to me, or your family has a history of it. But then, you have a terminal cancer diagnosis and you're receiving palliative care. You don't have the capacity to decide anymore, but you're obviously in pain. The concerns about opiates, they've they're mooted and the situation has changed. So if you want a DNR, you have to talk to your doctor, returning to your question. If you want to put end of life wishes in place in a medical um, document, there's something called a POLST, POLST. I think it's a practitioner's order on life-sustaining treatment. It's usually green, so people remember it, and you can ask your primary care physician about it. And that goes into some of the nitty-gritty. And it's a medical order that will be in the chart. Again, pragmatically, you've got a living will that's 40 pages long, that's essentially a medical textbook, and it's sitting in your desk. Your healthcare agent gets a call at 2 o'clock in the morning. They come to the hospital. They don't have your living will novel. What's it worth? So it's easier, well, it's easier pragmatically, but harder in the moment to just have a tough conversation with your healthcare agent about what you want. And I see that I'm running through a lot of time here. So I'm going to cut the questions there just for a moment. And I'm going to kind of breeze through the will because it can be pretty straightforward here, which is that it says what happens to your stuff. It can name a guardian for your kids. Names a person, an executor, executrix, if we want to be real traditional about it. That's for a female executor. And I'll leave the debates as to whether it's more progressive to use the executrix term or not to. It's kind of an actor actress type thing. I tend to just say executor or personal representative. Anyway, I just said I wouldn't ramble and we're running low on time and then I do that. But it's very traditional. It's very old. There have been, documents that say what will happen to my stuff when I die. As far back as ancient Greece, I was doing a little research and interested to see that. It must be signed by the person who's creating the will. It needs to have two witnesses. It needs to have a notary, and it can have some state-specific language that makes it easier to probate, meaning easier to handle with local government after someone passes away. Probate, very briefly, is the process of proving that the will is legitimate and giving the authority to the executor to speak on behalf of the deceased. And if you do not have a will, there are default rules about who gets your stuff and who will handle the paperwork called laws of intestacy. And they are set by each state. They're a little different on either side of the river. The Delaware River, sorry. I'm sure there's North Jersey folks here who are wondering what river I'm talking about, but I grew up in Mercer County, so to me the river is always Delaware. In terms of wills in practice, that's a whole other meeting. There's a whole bunch of stuff that can go wrong. The formalities can go wrong. People drafting it, if they're doing it themselves, even if they have all the required formalities, it can be tough to think about the what ifs. You give it to your spouse, okay? If your spouse isn't there, it goes to your kids. Great. Your kids don't have any kids of their own yet. They're 20 and 24. What happens if they're both deceased? I don't know. You might not know either. You got to think about it. It's tough. Yeah, you need to update things and check in on things. For folks who, again, going back to brain injury and thinking about that, somebody who doesn't have a will, um, nobody plans to have a traumatic brain injury, right? Things happen and it's tough. Motorcycle accidents, the one that I think of, um, all sorts of tough stuff. I mean, I don't have to go through, tough stories with all of you folks, but often those folks don't have a will. And in that case, you can think about trust planning under a power of attorney someone might have, um, or just dealing with intestacy or planning during life. But it's tough. It's tough to handle a will when someone doesn't have capacity, because I'm going to foresee a question here. An agent under power of attorney, generally speaking, cannot sign a will, a last will and testament on someone else's behalf. It's just not something that you can delegate. Someone can sign by mark if they have, limited ability to sign, like my client yesterday, but even just making an X. But if they are truly incapacitated and cannot sign or cannot understand what they are doing there, it's going to have to be another method. All right. Trusts. People ask a lot about trusts. Trusts are complicated. Trusts come in a lot of flavors, but to me, a trust is a box. It is a imaginary box. It is a legal box, but it's a box. And what does a box do? It holds things, in this case, property. Um, you transfer a bank account into the name of a trust. You can deed your house into a trust. You can sign a piece of paper saying that your collection of art is owned by a trust. A trust can file tax returns. A trust can make investments. It can do all sorts of things. But there's three parties to the trust. The first one has a bunch of different names, but it's basically the person who makes it, creates the trust, makes the box, and that's the client. That is not me. I sometimes get that question. I'm not the trust maker. You are, or the client is. There's a trustee who is the custodian of the trust. They are watching over it. They are investing things. They're making sure that the house is not falling apart, and the taxes are paid up, and that the beneficiaries are receiving what they're supposed to receive. And the beneficiaries, the folks who are allowed under the terms of the trust operating manual, the trust document, to receive property out of the box. That's a trust. All sorts of different flavors there. But the one that I'm thinking about, and I would think you folks should think about, are special needs trusts. Assets that are put into a special needs trust, if done correctly, can be used for the benefit of someone who is disabled, who has had a brain injury, who is receiving means tested or asset tested government benefits, essentially benefits that you can't get if you have too much money in your pocket. But they can still get the benefit from that trust without decreasing, for example, SSI. I'll talk about why that's allowed in a bit, but as long as it is supplementing and not supplanting the government benefits, then the government benefits will not be disturbed. A person might still get their housing subsidy. They might still get their health insurance paid for by the state, or incredibly subsidized. They might get a payment made to them each month from SSI. And note that I'm talking about SSI here because SSI is asset limited, generally speaking. Medicaid is asset limited in certain programs. SSDI, Social Security Supplemental Disability Income, is often income limited, but not asset limited. You could have $1 million in your bank account and get SSDI if you can't work. Not the case with SSI. So there are two different types of special needs trusts. I call them first party and third party. Once again, you are at the mercy of all the people who have thought that they have a very good idea about how to make this understandable to folks and have come up with a new name for it. But first party trust is also sometimes called a D4A trust. And this is where I get to use my law school degree here, but 42 USC 1396 PD4A is the statutory site for a federal statute for this specific type of trust, and it is strict. This trust must be irrevocable with an I, can't be revoked, can't be amended. Money that goes in cannot come back out into the person who funded it, except in very specific ways. And it is made by the first party, by the person who has the disability or the injury, or it's made on their behalf by a parent, guardian, a grandparent can do it now, before they couldn't. Someone who's able to speak on their behalf, or is just a family member. And what it can do is it can make it so that a person who has a little bit of money, but not a lot, can tuck their money into this trust and use it to supplement their government benefits while still receiving government benefits that are only for folks who are disabled and completely or very heavily impoverished. Okay. It must be created before the beneficiary turns 65. It must be funded before the beneficiary turns 65. And any money that is remaining in the trust unused when the beneficiary passed away, the first payer, the first beneficiary is the state. The state up to the amount that the state covered, so New Jersey or PA or wherever, that the state covered on behalf of that person as part of their, for example, Medicaid benefits. And they have a way to calculate it. They'll send a letter to the person handling the estate. They'll say, this is the amount that was owed, and we will take it. You must pay it from the remainder of the trust. If anything is left after that, which it usually is not, then they will, what's left will go to family members usually, or named beneficiaries. If there's more owed than remains in the trust, then the state says, well, that's doing business, that's taking care of folks with disabilities. We might come after the estate of that person, but they're presumably almost penniless, and it'll stop there. Other type of trust is a third party trust. This is not something that is in statute. And this is a trust that is created by someone other than the person receiving government benefits. It is funded with assets other than those owned by the beneficiary. This is if you're a parent and your child has a disability, you think they'll have government benefits in future, they should inherit in a third party trust like this, because it means they can get the benefit of what's in the third party trust, paying for dental care, trips, books, movies, music, things that the government may not cover under government benefits. And they can get that benefit and also get the government benefits, which is good. And the other thing that a third party trust can do that a first party can't is that a third party trust can actually impinge on what the government pays for. If that happens, the beneficiary will receive reduced government benefits, but there are plenty of times where the housing that someone can get or can have paid for by the government isn't as good as the one they could get paid privately. And the trustee of this trust can say, I'm doing this for my sister who has TBI, and the subsidized apartments where they want her to live, they just don't make sense for her. So we will just, forego that subsidy, decrease her benefit, and pay for it out of this third party trust, knowing that the government will say, then I'm going to give you less money, and just do the best thing for that person. You can't do that with a first party trust. It'll break the trust. It's against the rules of the trust, but you can do it with a third party, and you can make those on a much wider range of time. Ooh, I see that I'm running through a lot of time. Spotting who needs a special needs trust. Someone who is going to get means tested or asset tested benefits. SSI, certain Medicaid programs, some Medicaid programs are income limited only. And the idea is that they get that benefit from the trust, while also having government benefits that subsidize. Sometimes people say, why is this allowed? The answer is that government benefits are not usually enough. And in a strange moment of clarity, the federal government of the United States and the state governments have recognized that. And they see that these sorts of trusts help people who are often our most vulnerable and most in need of help. So that's why this is allowed, in my opinion. It's me editorializing a little bit. You want to make things smooth. I mean, get your paper set up. I mean, that's how I think happens. I would add to this slide in general, you should get good legal counsel, but again, I'm an attorney, so I think it's a good thing to have. A lot of people think attorneys belong at the bottom of the ocean. I think that's how that joke goes. Anyway, and you should if you can predict this kind of situation, then it's good to talk to a financial advisor and make sure your money is doing things and that you know where it all is. And that life insurance policy that somebody got 25 years ago as part of their job has a cash value and is going to screw up somebody's Medicaid application. You can tell that I'm only slightly bitter. That you know where it all is and that you set up trusts and things to make sure someone's taken care of. Let me see. Use us as a resource. Call our firm. You can call and talk to me. Um, I tend to be a little busy, but I try to get back to people as soon as I can. You can email. Um, you can talk to the good folks at BIANJ. There must be some like branded way to pronounce that, Barbara. Is it anyway? But you can check us out. We have a newsletter, all that good stuff, blah, blah, blah. You can ask and we'll send you some resources that we have. But really, it's about contact. Go back to the beginning. My information. I work in Trevose in Bucks County, but I practiced in New Jersey for 3.5 years before this. I'm in New Jersey all the time, so try not to hold my Pennsylvania address against me. And I see it's 12:58. We can take a couple questions. I can stay till about a little after, but thank you for your time and your attention. I hope you're all doing as well as you can. Barbara.
Thank you. Yeah, thank you very much, Ryan, for sharing your expertise on what is a really complicated but important topic. So we do appreciate it, and I encourage people if you have questions or need some assistance to reach out to Ryan, as he's posted his contact information there. There are a couple of questions, so let's see if we can get one or two of them in.
Yes.
I will also say that we have just posted the follow-up survey in the chat, so people can go ahead there and start to take the survey. So we had a question of someone who is a survivor, and he is asking what happens when his parent passes away and she has all the money that he received from the accident.
So hopefully she should have a plan in place so that if you're getting any kind of benefits that you've probably taken very significant efforts to set up, that they're held in a trust for your benefit with a trustee so that you can keep getting your benefits. I'm presuming that there was some sort of settlement or something that you're referring to there, and hopefully she's investing well for you. But the point is that your parents should try to have their paperwork set up ahead of time. So if something happens to them, there is another person, trustee, who can handle that on your behalf.
Okay, thank you. We had another, just to clarify, absent a healthcare POA, a patient's next of kin would be given healthcare information.
Yes. I'd have to dig into the HIPAA statute. There's defaults there for how that goes. But yes, a next of kin can receive the healthcare information. I don't like to rely on that. I'd rather have the piece of paper, the HIPAA release or healthcare power of attorney, so that again, when it's 6 o'clock, 8 o'clock, 9 o'clock in the hospital, and you're talking to one person who isn't sure they can talk to you, you could say, "Oh yes, you can," and here's the document says you can. But sometimes you can squeak through without it. I just don't want to guarantee it.
Okay, thank you.